practicing immigration law exclusively since 2010. I started my career in the deportation courts, running to the border to help the asylum seekers. And in 2013, I actually transitioned and started working with an online immigration service provider as their subject matter expert and their compliance expert as well. So in the last 4 years, I've immersed myself in immigration DIY, do-it-yourself software. I've helped develop wizard algorithms, process flows, and train customer service, sales agents, engineers, and developers on all the legal compliance and immigration processes, okay? So I really have an in-depth knowledge of the complexities of UPL, which is unauthorized practice of law and technology, and also limited scope review and the regulations across all 50 states. So here at the Boston Law Firm, I want to start, the first thing is our mission, and our mission is providing access to justice. We use technology to provide access to justice to those who may not be able to afford traditional legal services. They may be located in remote areas or underserved, areas underserved by the legal community. And we really try to work with other companies that have the same types of missions, all right? So who do we serve? Well, we serve online immigration service providers. These providers include companies using technology to allow people to complete their immigration, fill in their immigration forms online. I believe here at CodeX, you all have seen presentations of other similar companies. So those are the main people we serve. It's a B2B business model. So the way I like to say it is think TurboTax from immigration. And I know a lot of these other companies have said similar things. So where do we fit into this whole process flow? Well, the immigration service provider generates the form. The user comes to their website generates the form either through a wizard, bot, whatever they're using at the time. Then the service provider sends that form to the Boston Law Firm. Our platform picks it up and we're able to assign that review to attorneys across the country. We have attorneys all across the United States. They speak several languages. They're able to work 24 hours a day on the weekends. So just like with the TurboTax, as you go through the whole system, and at the end it says, would you like to have an accountant review your form? Well, in steps the Boston Law Firm to allow attorneys to review the forms for them. We are able, for the forms we're using and our service providers' demands currently, we're able to get the results back to the client within 2 business days. So why do they even need us? Like, what's the point? Well, basically, I'm going to start, because I know this is a very diverse group, and a lot of people have different understandings about immigration. So let's just talk about numbers of immigration stats. First of all, as we all know from the news, immigration is a hot topic right now. Because of the changes in administration, a lot of immigrants have a lot of fear and confusion about the process generally, as well as other non-immigrants, of course. So right now, there's about 84.3 million immigrants, plus their US-born children in the US. It's about 27% of the population. In 2017, for these types of applications, family-based, petitioning for your family member, naturalization, and then green card renewal, with over 2 million applications received from to the USCIS, that's this year alone, and we're not even finished with 2017 yet. Now, of those 2 million cases or applications they've received, only 63% have been approved. So, there's a lot of reasons why applications don't get approved. They may be ineligible. They may have put incorrect data in their forms. They may not have followed all the immigration procedures. Did you show up to your interview, right? Or they could have improper documentation. So there's a lot of pitfalls that could befall the poor immigrant who's doing this for the first time, right? So what are the industry risks for these online immigration service providers? Well, first of all, there is very high scrutiny from regulatory bodies. Again, here at CodeX, you guys have heard from companies that participate in this, and you've also heard from the lawyers that are saying, whoa, hold on, your technology is going too far. So, you got AG's office, you have consumer protection agencies, you have state bar agencies. And really the reason that this is such a high risk in immigration in particular is because there's this thing that we call the notario problem. basically, there's groups of immigrants that go to notary publics to help them fill out their immigration forms. It's very common in other countries, so they think it's okay here. These notary publics end up getting these immigrants into a lot of problems, sometimes even resulting in deportation. So everybody started cracking down on this. And you know, the regulatory bodies want to make sure that the immigrants that are using these services, these online services, aren't falling victim to the same type of prey as these notaries. There's also the problem with unauthorized practice of law and technology. There's a line that you can't cross, right? Your technology can only do so much, at which point, at some point, it's not an attorney, and it can't go over that. So that's a really big concern and thing that these types of companies are dealing with. Obviously, it all comes back down to if they get it wrong and if they don't follow the regulations, then they get sued, right? So that's the worst case scenario. But it also takes time and money to deal with complaints from AG offices and everything else. So that's another pretty large industry risk. And then, of course, there's just negative public perception. All of us here at CodeX, you understand that this is a completely new, disruptive area. People aren't comfortable everyone's not necessarily comfortable using the internet to give this type of sensitive data, to do these types of processes that are very important to their lives, right, to keep their families together. So, trying to get over this negative public perception, bringing in an attorney really helps these companies get past these risks. So then, the next thing is, well, what are they doing about it now? A lot of these companies do have some type of lawyer review program with them. Well, there's three things really. They can hire in-house attorneys, right? Well, attorneys are expensive. So it's a higher upfront cost. It's difficulty scaling. You can only hire so many attorneys, and your demand, especially online, is way higher than most lawyers are used to dealing with. And then, of course, it distracts them from their main focus. They're there for the technology, not to manage attorneys or be a law firm, right? The next option is to develop and manage their own attorney network. Again, there's difficulty scaling that. It distracts from maintaining quality control. There's a lot of lawyers around here. We all know that one lawyer's thoughts on how something should be can be different than another lawyer's thoughts on how it should be. So, knowing that your users for these online immigration service providers, knowing that their users are getting the same level of customer service no matter what lawyer is reviewing it is very important, right? And it's very difficult if you're trying to manage that. And trust me, I run an attorney network. People cancel, they reschedule, they have a court case, and you really have to be quite agile to be able to respond to those types of needs. And this, again, distracts from their main focus, developing technology, not managing attorneys. The last is they can choose to contract with a third-party attorney network. Now, all of the third-party attorney networks, from what I've seen, still run a traditional model. They'll connect you to lawyers that have signed into their network, but those lawyers are still doing the work manually. They're still, getting paper forms, reviewing them, coming back, maybe sending emails if you're lucky, maybe chatting if they're a little more savvy, right? But there's a big lack of oversight. Once the company, the immigration service provider sends these to them, they don't know what attorney it's going to hit. They don't know what necessarily that attorney is going to say or what level they have in the field. And it just kind of gets frustrating and complicated, especially if issues start coming up. It also takes the customers out of their sales loop. They're not coming back to the immigration service provider for more services. They could potentially be going to that attorney or something else. Now, whether they do or not, we don't know necessarily, but it is a potential risk. Again, difficulty maintaining client control. We've already talked about that. And then for number 2 and number 3, the biggest thing with those is these attorneys may not have an in-depth understanding of the product, of what the online immigration service providers are doing. So that just messes everything up because they'll start talking to their clients and questions may come up. So it's just not the best way to handle things. So what solutions do we offer? Well, number 1, we offer scalability. With using our platform, we can meet all kinds of fluctuating demand of our scalable attorney network. We've reviewed over 23,000 applications across several online platforms. Consistency. Each client receives the exact same level of service and quality regardless of which attorney is reviewing the application. We provide initial training for all of our attorneys. Every attorney that joins the network gets at least 40 to 50 hours of training on our process and our platform before they even review an application. So we make sure they're doing it to our standards and the way that they should be as part of our network. We also conduct regular quality control checks of the attorney's work to make sure that, no one's falling off, they're able to keep going at the same speed. So our process guarantees consistency, speed, accuracy, and quality service. 3 and 4, protection and agility. The way that I like to say this is that what our law firm does is it offers the protection of a law firm from those industry risks that we saw before, plus the agility and scalability of a technology company. And then there's customization. So our processes and systems are tailor-made for these online immigration service providers. I worked with them, I know what they need, I know what their problems are. So this whole system was built with that in mind. They're also able to customize their service offerings. So obviously there's lots of competitors in space. If one wants to have longer phone consultations or additional forms or different applications, we can accommodate that.
How do you guarantee consistency? I mean, I understand quality, you've checked people and so forth, but how do you guarantee consistency? I mean, different attorneys may have different.
I'm going to show you. That's a great question, and I'm going to address it. So again, our process focuses on technology, allows these immigration service providers to focus on technology and not on managing attorneys. A gentleman here, I don't know if everyone could hear that, he asked me how I guarantee consistency amongst the attorneys. And I said, hold your horses 1 second. I am going to show you exactly how that's done. So moving forward, sorry, too far. No, these are just some of our value adds. I'm not going to go over them all. We've talked a little bit about them. We're able to support several languages. Right now we have English and Spanish, but we can easily add another language, not a problem. Flexible remote hours, constant coverage to meet all time zones. Well, people on the internet don't work 8 to 5 Monday through Friday, right? The majority of attorneys do, or 9 to 6, or that's when their office hours are. But our attorneys are able to work across the scale. Of our attorneys, some run their own law firms, some are stay-at-home moms, some work for another law firm and they do this on the side. So they're really happy with this, and we have a pretty high attorney retention rate. Sorry. There we go. And the one, like I said, we have quality assurance. All of the client communications are centralized in one place, which I'll be able to show you once we get into the demo. One of the biggest things, though, is that we're able to provide the online immigration service providers is we're able to provide feedback on their product constantly and consistently. We have, we've reviewed 23,000 cases. So we've been able to look and find the common issues, the common responses, the things that keep coming up, and we're able to give that feedback back to these companies so that they're able to make their product better, which makes our job easier, which makes everybody go faster. All right, we're gonna jump into the demo here. So when an attorney logs in, the first thing they come to is the login page. They'll go and they're able to see which types, how many reviews they have for that day. So they can see how many reviews are in their queue. All of the reviews that they're supposed to do that day come up. Now, as you can see, there's time limits and things like that, what are due today, what's at risk. So the really big thing about this is we have a 2-day business turnaround. So we do want them to keep that in mind as they're doing reviews, which ones are due today, which ones have the deadline. So an attorney will go and they will decide to do a review. When they open up the review, the application comes up. All right, so they can see the application, they can scroll down, see all the questions they're asking, etc. Now, if they run across an error, they're able to add an error. They can pick which document. Some of these processes have several different applications. They can pick which question, and then they can select which type of error. Let's say the middle name was abbreviated when it asks for the full middle name. When they do that, the response automatically generates. Again, after going through 23,000 applications, I would say 90% of them have the same issues coming through. So we've already gone through them and created common responses. This cuts down on the attorney having to draft the information. They don't have to think about it, but they do have the option for independent judgment. They can still add information, change it as they see fit. But because, you know, we've had so many attorneys and they all have chimed in on this process, what we found is that our answers are pretty solid. You know, we have 10, 12 attorneys going into it. They're able to put information in, and they can give feedback to me. We can change things get updated, etc. Once they do that, they'll save. And then let's say we were talking about that situation, you know, everything is not a common response. They will find things that are not already on our common response list. Well, let's say that there's something that comes up that's very specific to that case. Well, the last thing we want to do is take away our attorney's independent judgment. So they're able to actually go and create their own. We have them divided by major and minor, just because, you know, major would be cases that could cause rejection or denial of the application. Minor is something that doesn't exactly follow the instructions. And then they can say what area it was. Let's say, obviously, illogical entries. All right, so then the attorney is able to actually add their own responses as well. All right, so then they'll save it. When it's time to send out the review, they can go and preview the email that the client's going to receive. All right. They can see which areas there were conflicts. They can see what type of errors that they added to this. They're also able at this point to edit in case they hit a wrong button or mess something up. They can edit from this page as well. The client will have a link to access the results later, to schedule phone consultations, which is here. All right. And then they'll hit send and exit. Now, when they do this, a text message is sent to the client, to their phone, letting them know that the review is ready in their email with the email address we have on file, because we all know everybody types emails wrong sometimes. And they'll know exactly when their review is ready to go over. Now, we were talking a little bit about the reports to give back to our online immigration service providers. So here, as you can see, we're able to let them know how many cases have come in, what type of issues we've been seeing with the cases that have come in from their application, what are the common issues we're seeing, okay? So we're able to offer all that feedback back to our provider partners about their system. There's actually more we can offer as well, depending on, you know, what we need to pull from our data. And then the attorney, the last thing I'm going to show you is the attorney can also see their own stats. They can see how fast they're going, how many cases they've done, what type of errors they're spotting, you know, things like that. Now, sir, to answer your question, how do we handle consistency? Well, the common response is the main way that we make sure that everybody's getting the same type of information, along with the attorney training as well. And there's constant review. Okay. All right, so let's step out of that. Oh no, where did my presentation go?
Is it a PowerPoint?
Oh, you might have closed the application.
I did. Okay, 1 second. Let me just pull it back up. Okay, are you still able to see my screen? Should I stop sharing my screen for a second?
I think you may have
Stop because I
yeah.
closed it.
Yeah,
okay.
you close the
You
application.
just hit your share screen.
I have to pull it back up.
Yeah.
Sorry. Sorry, one moment, technical difficulties. Right, I'll go here, no.
Share screen.
Sure.
This one. So just hit here. How do you click?
I know. Go back to presenter view.
Ah.
There we go. Now. All right.
Yay.
Yay, we're back on. Let me just get back to where we were. All right. So what's going on? What's next for the Boston Law Firm? What other things do we have in the pipeline? Well, the one thing that we're really excited about is we are currently integrating, we're developing machine learning capability. This is already in development. We're hoping to have it released by first quarter of next year, if possible. So by using the extensive data we've already collected, we're actually currently identifying methods for the system to instantly identify these common errors that may, or the errors that may contain the same response throughout the document. So these trained neural networks can actually help in detecting patterns. This will result in further reducing the attorney time and the risk of human error during the review process. You know, like we're not trying to get rid of attorneys. I feel like I have to tell that to attorneys. It's not the point of it. The point is to make the attorneys go as fast as possible when it comes to doing these reviews. And then we also have telelaw features that we're enabling. So similar to the telehealth model, we're developing a system for clients to immediately consult with an attorney through the convenience of live video. So this does two things. Number one, it further helps us meet our overall mission of providing access to justice. And it also serves as a bridge for those clients who may not quite be comfortable yet working with an attorney without seeing them. All right, so I'm going to go ahead and answer a few of your questions ahead of time, and then we'll wait and we'll see if you have any more afterwards. So one of the big things is, you know, how do we collect cases? Well, there's currently two ways. Currently, the providers use a case management API that we integrate into our platform. But we're also developing a simpler process where a provider who may not have that infrastructure in place yet can push these cases into our platform through an API. You know, what case information is archived and for how long? Well, there's two areas, right? Technically, the data and documents we collect from suppliers, we keep. And in addition, the platform registers any access, communications, and things like that. In a specific case of client forms, a register with these actions is generated with the associated case. So once, you know, every time we send an email, every time we have a phone call, every time a text message is sent, a client log is generated in the platform, which reduces admin time. We're attorneys, we all have to keep this information, but our attorneys don't have to worry about that. And then legally, we follow the best, the record-keeping requirements for each state. So most states, it's between 5 to 7 years that you're supposed to hang on to your client data. So where is this data stored? All the data is stored on US servers. The customer documents are also stored in a special Google Drive account. What about security? The big security question. So at present, what the security measures we have in place presently, it's only possible to access the information stored on the server by digital certificate. In addition, to ensure integrity, encrypted backups are performed on 2 different servers. As far as security to the access to data, the only way the user can access the information is through the platform. So once the login is done, a temporary token is generated that serves for the same session and is restarted on exit or when they relog in. In addition, all connection to the server is encrypted using HTTPS, which prevents anyone from reading the information during the transit to the server. Now, I get this question from my online providers. They were like, what about their trade secrets and intellectual property? Well, we do not share any information about our providers with the other providers. We are, of course, a law firm, and we follow the same standards of integrity and confidentiality with our providers that we provide to any of our clients. And then, do we provide a la carte services for our providers? I mentioned it earlier. Yes, we do. We have the capability to give them what they want. Some want different forms. Some want different time of days of response. People want additional phone consultations, et cetera. We can do all of that. All right. This is my contact information if anyone wants to have more information, and I am open for questions.
Great, thank you. So, yeah, very cool. So maybe take maybe 2 or 3 minutes for questions, because we actually started a little bit later since we had our introduction at the beginning. I mean, what's so interesting is that I think you identified, somebody's typing. Can you mute that? Let me see. Some background noise here. All right. So I think what's fascinating to me is that you're exactly right. What you said at the beginning is there are these technology, these online players who have new ideas around how a specific legal service can be provided, but they always hit that sort of that point where their solution can't really provide the legal service because of UPL issues, and so they would have. As sort of almost as a backup to their service, they need this network of attorneys who can give the human lawyer review on top of that, and that's a very different, as you say, that's a very different task to build a network and maintain a network from like building the technology front end, right? And so that's where you saw the opportunity, and that's so interesting how you address that opportunity. And I think that probably can be used in many other areas of law, where you have like an online service that tries to kind of bring in the people with the legal needs, and you have to distribute it to you need to create a network of human lawyers on the other side that can provide that review. Yeah. That's the one. And the other thing is interesting because I hadn't realized that. That what you have the lawyers do is pretty much, you send them finished materials, right? And you say review, and then they can raise a flag. So you already take it very, very far, and it's just the human lawyer is basically just as a backstop in the sense that if there's a problem with that, right? They're not creating the materials themselves.
Exactly.
But is it your firm that creates the initial draft, or is it you gather, if you have to say a chatbot who's on the other side, your online service provider? Don't they create a lot of the initial materials and then you hand it over to?
So as far as the actual immigration form, the completion of the form, we don't do that.
That's the online service.
The online service provider. We get those completed forms, and then what we've done in our firm is we've gone through those forms painstakingly, question by question, and come up with, put our attorney hats on and come up with the most common issues we see with the forms we're getting from that provider. And then we've created a full database for every one of our forms with, hundreds of common responses to each question that we've programmed into the system.
And okay, but if you have that complex, if you're taking on this task, why do you not handle the review yourself?
That's a good question, and a lot of people have asked me that question. Currently, where we are, and my position is, I want to function as a law firm. And one of the issues that I didn't actually mention it here, but one of the other issues that comes up is, we're a law firm and that's using technology and developing technology. We're not a technology firm. We also have, there's a lot of, going out there.
But that would be a legal task to review the document. Sure, to
create the document. Yeah. That is true. But I also don't want to really deal with going out and getting the customers. Mm-hmm.
No, but you're between the online service provider. Right. Then there's your law firm, but then you also have a network of independent lawyers that you're maintaining.
Correct.
But you could potentially also just be the one-stop law firm that does the review for the online service providers.
Exactly. That's what we're trying to be. That is exactly
But
what we're
why
trying
do you
to
need the network around it then?
Those are the network or the attorneys that are doing it. So it goes back to scalability again.
So it's just for you to be able to handle all that demand, you need more than just, okay, I get it. Okay, makes sense.
Exactly,
Okay.
yeah, exactly.
Yeah, I get it.
Sorry, I didn't understand your question first.
That's a very interesting presentation. So I am a computer scientist. I ask myself, so why is there still this analogous document that we fill out?
Right.
Why isn't there something like we have so many smart technologies that we can enhance this process, or we do not even allow for any misleading or wrong values within these documents. And I think like rule engines and what you showed us, these errors. There's so many. I don't know. I guess it would be rather easy to formalize it, at least to a certain degree.
Right, I agree with that, and that's kind of where we're going with the AI and the machine learning stuff that we're integrating now, is to start doing exactly what you're talking about, identifying those technically, so that, for example, if someone says question 1 wrong, question B automatically is going to be wrong or something like that. And that's exactly what we're working on now, is identifying those kind of things. But I don't think you can necessarily like I said earlier, can't take the attorney out of the process, because that's what creates the protection, right? But with the improved technology, what we may be able to do is have less attorneys do more do more reviews,
right?
Because it's already been identified for them. That's exactly where we're headed.
It's right, this disruption. So we don't need this process outsourcing any longer, because there is nothing to outsource. The machine does it 24 hours a day.
Sure, that's where we'd like to get to. I don't know if the legal community is ready for that yet.
Well, the legal community has to help you build those, those kind of controlling questions and the rules,
right?
And then it's even more scalable.
Absolutely.
I think the other thing is that you're dealing with people who aren't technologically sophisticated on the other side necessarily. Like the people who are applying for immigration and things coming through, they might not identify with the hard-coded answers you put in there when they're answering those questions. So I think you still have to build in some flexibility for the fact that your users still, and a large portion of the population, aren't sophisticated enough yet to be able to navigate a
I think that's a good point. The challenge of matching a real-world fact pattern to a determined rule, right? That's the kind of.
Especially if you have a language barrier and things. If you've got English and Spanish so far, if I'm coming in and I only know Chinese, I'm going to probably go through the English one.
No. Well, correct. Now, unless our providers ask for us, because they have so many, Chinese users, we can add that too. And we are actually, working on adding that. A lot of my attorneys speak other languages other than English and Spanish. I have a Vietnamese-speaking attorney. I have an attorney that speaks one of the, I don't want to say which one's wrong, one of the native Indian languages. So we're actually thinking about that as well.
So maybe we can take, I think Yin had a question.
Yes, hi Yin.
Yes, hello. Hello from New York. I had a quick question about the regulatory aspect of the business model. Is it correct to say that the attorneys who actually log on and do the form reviews, those are essentially contract attorneys, right?
Yes.
Are you concerned at all about potential ethics rules kinds of issues? In New York, and I don't know if California is the same, but in New York, if you have a large collection of lawyers working with each other, even on a contract basis, there is a possibility of incurring very, very burdensome obligations to perform conflicts checks against essentially across very large sets of attorneys. I mean, is that something that's a concern?
Well, yeah, I mean, so there's a couple of things. They are contractors. They are all insured under the Boston law firm for the work they do for us. So we definitely carry legal insurance for them. And, when it comes to the thing about immigration is yes, you have to do conflicts checks. And yes, the attorneys, that are doing the reviews, if they see someone with information or something that looks familiar with one of their old clients or someone else they may know, they can do that as well. It is a concern, but it's not something that's come up at all since we've been doing this. And we do try to of course, always follow the best practices of every state bar, which is, burdensome but important, because we are attorneys, and that's the most important aspect of it. I don't know, did I answer your question? So yes, I guess the short answer is yes, it's important. Yes, it's something we take into consideration. No, it's not something we've had any problems with to date.
Mm-hmm. Great.
Okay,
So maybe the final question before we turn it over to Yin is from Danielle, who's asking, what's the business model? Do you charge a subscription to the attorney?
That's a great question, and the answer is no. The business model is B2B, business to business. Our providers are the ones that send us the cases, and they usually send the price of the review. They have their users pay the price of that legal review. But no, I don't charge a subscription to the attorneys to be part of the network. We actually pay the attorneys to be a part of the network, and there's a couple reasons. I've thought about the subscription idea, but I want to create an atmosphere where the attorneys feel welcome, they're not incurring additional costs, and it's a way for them to also supplement their business. So the answer is no.
All right, maybe very final
One last question.
Sure.
Have you considered maybe using decision trees as well as machine learning? Because some of what you're examining looks like an ideal machine learning candidate, and that there's kind of murky reasons for being rejected, the incorrect information and so on. But on the other hand, some of it's codified, like there's very strict eligibility requirements, like if you meet this requirement, then do you meet this requirement, then do you meet that. And then if you had a decision tree doing that analysis, it could say, here's the part of the decision that the computer can explain. Then the attorney would spend less time blessing that part of it. Whereas with the machine learning part, the attorney's going to have to go over it, and the computer's not going to be able to tell them why they made the decision, but the attorney's really going to have to review that more intensively.
Yeah, actually, yes, we have. Yes, we are. I didn't specifically state that one, but yes, we are also incorporating the decision tree as well. Yep.
All right. Well, wonderful. Thank you so much.
Thank you, guys. Appreciate it.
Please, and I will turn it over to Yin.
All right, great. So I just go ahead and hit share screen, right?
Yes.
Yep.
Okay, let's see. Okay, here we go. Everybody can see this?
Yeah.
Okay,
yes.
Great. So yes, I run a website that is a patent search and visualization tool. It is called Obvious because, well, it's a pun on the obviousness standard in patents, but also it does make information a lot more easily retrievable than existing websites do. So to give you a little bit of background, I graduated from law school in 2012. I have been essentially exclusively a patent lawyer since then. And from really day one of practicing as a patent lawyer, I noticed that there were just certain persistent problems with the way information is retrieved and cataloged in the practice of patent law. And one of the major issues that I identified, even at that early stage, was an inability to retrieve so-called patent families in an efficient and easy way. We'll get into specifically what patent families specifically are later. For now, it suffices to say that patent families are essentially groups of patents that are connected by special legal relationships. And when you have a group of patents that are related in that way, there is essentially an obligation to look up all members in that set of patents. It no longer suffices to look only at a single one. And essentially, this is where most of the existing patent solutions fall short. If you look at Google, if you look at Lexis, if you look at Westlaw, by and large, all of those websites are focused on showing you one patent, either the PDF or some other textual format at a time. And it turns out that looking at one patent at a time, in many cases, especially in complex cases, just is not sufficient. So to summarize, yeah, patent families are a real pain point in legal research. The current solutions they're not good enough, and they often require you to basically default to manually looking things up. This ends up being a huge bottleneck in case preparation, and there's a lot of pitfalls for inexperienced attorneys if you don't know exactly what to look up. All right, so moving ahead, now we get to the question of, well, what exactly is a patent family? It turns out that way back in 1952, when the current patent system was put into place as a statute, certain provisions of the patent statute, which is 35 USC, allow an inventor to not only submit a patent, but to submit multiple patents and declare what are called priority claims from later patents to earlier ones. And the whole point of doing this is to allow certain legal benefits attaching to earlier applications to pass through those priority claims to later ones. You can think of it as a kind of inheritance mechanism for certain kinds of legal status from patent to patent. The chief benefit here is by availing yourself of this kind of benefit. It often makes it possible to obtain patents for a larger scope of invention that would otherwise be available. So that's the benefit. Well, what's the downside? It turns out that the downside is that in order to properly avail yourself of the benefits that are allowed under statute, you have to make very, very specific statements in the patent application about what kind of benefit you're claiming. And it turns out this is kind of a legal landmine area, as we'll see later, because if you screw up in the language, which is very, very specific, you could potentially end up in a situation where not only is the priority claim not established, but your own previous inventions and patents end up being prior art against your current patent applications. And that is absolutely disastrous, because if an opposing party finds out about that, there's virtually no way for you to work yourself out from under there. So as a final note, I will say that in terms of law, which I don't want to bore people with, the core statute here is 35 USC 120. That contains something called a specific reference requirement, and it's out of that requirement that everything else grows. All right, so to give everybody a concrete idea of how priority claims work, essentially every priority claim is a scenario in which you have two applications. We've called them A and B here. A is just going to be the earlier one in terms of filing date, and B is going to be the later one, which we call the current application. We're going to pretend that one is the one we are currently working on. Priority claim is very simple. It's an arrow pointing from A and B, and certain legal benefits like filing dates and priority dates and so forth flow through that arrow from application A to application B. More concretely, suppose that application A is filed on 2016 January 1, and application B is filed on 2016 December 1, basically 11 months later. If we maintain them separately, then well, both just proceed on kind of parallel tracks, and whatever happens in patent examination. But provided certain requirements are met, an inventor can declare a priority claim connecting application A to application B, and you can see the relevant text highlighted in red. And the most salient effect is that the priority claim allows the filing date for application A to then pass to application B. Essentially, the filing date of 2016 January 1 overrides what would otherwise be the filing date of 2016 December 1 for application B. And the net effect here is for application B to be teleported back in time, as far as the law is concerned, by 11 months. And this is of great relevance in a lot of fields, like, for example, cell phone technologies and so forth, where a lot of new things can happen in 11 months. And if you have some way to gain an 11-month advantage against prior art, which is to say pre-existing inventions, then that could be a real benefit in patent examination. Now, the caveat to doing this is that when you claim, when application B claims the priority of application A, it has to make a specific invocation within the text of that application that effectively amounts to, I claim priority from A. The specific phraseology we can talk about later. There's case law about that, but you have to expressly say there is an application A and I claim the priority of that application. That's what makes the priority claim valid. Well, if you just have two applications, the scenario is relatively simple because there's just intrinsically not that many ways to screw things up. Where things become interesting is if you start chaining together more than two applications. And as we'll see later, this is a routine thing, and these chains can become shockingly long. But looking to our example in this slide, we have added beyond application B another hypothetical application C, which is filed in 2017, December 1. So again, we have now 3 applications. Now, if you just look at how these arrows are wired up, effectively what you have is a situation where application A is giving its own filing date to application B, and then application B is turning around and giving a filing date to application C. Was there a question? No? Okay, I thought I heard something.
Picked up some.
So if you simply look at this diagram, it is intuitively very tempting to think that because there's an arrow going from A to B, and then another arrow going from B to C, that necessarily anything from application A will just naturally follow both arrows down to application C. It turns out that the Federal Circuit has ruled that this does not work. If this is all you say in the 3 applications A, B, and C, then guess what? The best filing date that C gets is actually application B's filing date. So C effectively gets shifted back in time to 2016-1201, which is when B got filed, and that's the end of it. You can imagine that this would cause problems if you mistakenly think that C actually got A's filing date, but it turns out that you're short by 11 months on the calculation. And again, this is not a pleasant thing to find out in the middle of a patent lawsuit, which has happened multiple times at the Federal Circuit. So again, so how do you fix this? Well, it turns out that if you truly want application C to claim priority all the way back to application A, you have to say that both application A and application B exist. So if we look at the bottom of the diagram, C has to say there is an application B, I claim the priority of that, and furthermore there is also an application A, and I also claim the priority of that, and that's how you appropriately pass filing dates and other kinds of legal benefits through more than one successive thing in this chain of priority. So you can see that because of the way the rule works, the recitation of previous applications gets more and more burdensome as the chain gets longer, right? Here, just as an illustration, if you add on yet another application D, then guess what? Application D has to cite the 3 things before it, so it has to say C, B, and A, and if you don't do it, then we get the issue of things not getting passed along as they should, and unexpected bad things happening later on. Well, it turns out that when you have a very complex case, like something involving a 4-patent chain of priority, things can go wrong in ways that are not detectable simply by looking at a single patent. So here I've set up such a scenario. We start out with A and B, those are fine. We get to C, but C has a problem. Specifically, the inventor wanted C to have the priority of A, that is to say A's filing date, but guess what? The inventor screwed up, and he didn't write priority from A in application C. So now as a result of that, application C only gets the 2016-1201 filing date from application B. Oblivious to this error, the inventor then goes on to file application D, and he still thinks application C gets the priority of application A. So he goes through, he goes into application D, and guess what? He does the right thing, right? Application D says, I claim priority from C, and then I claim priority from B, and finally I claim priority from A. Now, if you look just at application D here, you'll notice that application D in this problematic scenario looks exactly the same as it does in the normal, well-kept scenario before. Right? If you look at D, it says C, B, and A. What's the problem? It seems like everything's fine. Well, it turns out that because something prior to D in the chain was broken, guess what? Even if you try to fix that problem essentially retrospectively in application D, that doesn't work. And this is a huge problem because this now imposes on the inventor an obligation to go back and check basically everything that's been filed before. As a side note, I would say that so far we've been talking only about a single linear chain. It turns out that there are ways to end up with seriously pathological scenarios involving these kinds of relationships. This is just one of them. There are multiple scenarios out there where one application A starts out being a single application, then you get two separate ones that are in parallel, and the two separate ones try to merge back into application D at the bottom. And then questions come up, you know, if A to B has a priority problem, well, is it possible to circumvent that by going from A to C to D? And this is literally a question that's never been answered by any court. So my expectation is sooner or later someone will be forced to litigate that, and we will all find out what the problem is. Enough with examples in terms of what's actually happened in real life scenarios. Well, just in the last couple of years, there have been two cases at the Federal Circuit where the scenario I just described in applications A through D actually happened. The first one, this Medtronic case, was in 2014. One of their patents got invalidated because of that exact scenario where you had what looked like a totally legitimate patent on its face, but something earlier in the priority chain of that patent had some formal defect, and guess what? That broke the priority to an extent where the patent was invalidated by prior art that otherwise would have been avoided. Slightly earlier, the same thing happened in this Encyclopedia Britannica case. There, two patents were found to be invalid for exactly the same kind of hidden formal defect. So what does this really mean for people who practice law? Well, again, there is now a very extensive requirement to go and check everything previous to a certain patent that you want to assert or you want to apply for, or really you want to do anything with. And it's worth noting that the requirement of inspection extends not only to issued patents preceding the one that you care about, but it includes abandoned applications, including ones that have not been published. And again, if anybody in the room has worked with USPTO disclosure rules and USPTO systems, you know, this is not an easy thing to deal with. All right, so we're going to take a look at how Obvious works. Everyone can see the browser, right? So Obvious basically draws these graphs instantaneously, which you basically
no, we don't. We can't see. We can't see your browser actually. You have to share.
Oh, I have to do a new share. Okay, hold on. New share.
You share the PowerPoint.
Yeah, hold on. New share. Let's see. Obvious Google. Okay, share screen. This should now show Google, right?
Yeah. Now we see it. Yeah.
Okay, so you go to Obvious's website. There's an issue with the Obvious domain name involving previous web hosts, so I had to use a temporary one. So you'll see that once you load Obvious, right now I've set it up so there's a demo search, so everyone can see how it goes. We're looking at patent number 9,000,001 because that's just a nice round number, and you'll see that 9,000,001 is right here toward the lower center of the graph, and you'll see that 9,000,001 claims priority relationships to a number of preceding patents. There's this thing that's 8,270 something, and then there's a number of so-called priority patents. These are PCT, they're international, and there's certain other special types of patents that all give some kind of legal benefit to patent number 9,000,001. And basically with this search tool, a patent attorney who otherwise would have to figure out by hand, by picking through USPTO records, what are the priority applications relevant to 9,000,001, you just type in the number and immediately you get 1, 2, 3, 4 priority applications that come up, and immediately the lawyer can then proceed to just check each of those applications to see if everything is legitimate and squared away. So that's how this works, and you can on your own time go and look up other patent families, 9,000,002, 9,000,003, and you can have fun with whatever numbers you can make up. Coverage-wise, it starts in the mid 4 millions, I believe, and then it goes all the way to essentially the mid 9 millions. So it's a significant amount that you can look at. Now, to satisfy everybody's curiosity, I did look up the patent families from those two cases I mentioned. This is the one from the Medtronic case. And you can see that this is just a real monster patent family. In fact, I'm having trouble even finding the patent number that was asserted. But you can see that this kind of scenario is really I would say representative of what happens with the patent holdings of large companies. People, I would say, just they inattentively claim priority from various applications without necessarily thinking through the consequences and the requirements, and then things go wrong at a later date. And if you count from top to bottom, the topmost application, there's 1, 2, right, 3, 4, 5, 6. So I mean, so some of these things are 7 items deep in terms of priority chains, and I think a really good question to ask is, has anybody actually gone through that 7-item chain and made sure there isn't some defect midway through it that really damages everything later on? And I think that's a question that has not really been asked. Even though it is required by law now. For your further amusement, these are the ones from the Encyclopedia Britannica case. We'll talk about why some of these are separate for now. That's actually a data quality kind of issue. And actually, I think these two come from the same family, so it's the same graph. Yeah, it's the same graph. All right, so let me reload the presentation and we will finish up. It's back to PowerPoint, right?
Yes.
Okay. We'll scroll through all of these. Right. So that's what Obvious does. And again, you can explore to your heart's content. A couple of technical notes. Coverage, it starts in 1976 and goes to the present. I would love to have everything going back to patent number 1, but it turns out that I need electronic records, and the electronic records only go back to 1976. We do better with the U.S. patent application publications because those only started in 2001. So electronic records have been issued from the beginning. And right now, a concern I would say is how do I get access to all of the abandoned applications? The coverage, as far as I can tell, is pretty good because anything that is relevant to a issued patent or patent application is already disclosed. So there's maybe some stragglers, and I am looking into solutions for those. This brings us to directions for future development, which is, first of all, it turns out that the Patent Office has in fact made a separate collection of data available for just applications. This is from a system called PAIR, Patent Application Information Retrieval. Again, if you work in patent law, you've probably dealt with it more than you care to. Besides that, I would say, really, my agenda for future development is, number 1, how can I automatically detect defects in a priority chain? I think that is probably doable, and that would also be very useful because then you can immediately know if there's something wrong without having to visually inspect everything. And then further down the list, I'd like to get full text patent search going. That would be useful. Faster search speed, certainly, and finally, additional search criteria like search by inventor and assignee, which is often practically useful. The final note here is that it turns out that there are 2 sources of priority information sometimes. There's the text of the patent application itself, which is the specification referred to, and then there's a supplementary cover sheet called the application data sheet, which the USPTO uses for bureaucracy purposes. And right now, the law is completely silent as to what happens when those 2 sources of information don't agree with each other. So stay tuned for decisions on that front. And that is it. So if you have questions, please feel free to let me know.
Great. So we're a little bit over our time already, but I wanted to see if there's maybe someone who has a question for Yin. Yin, what's your business model? Is this a free service at this point, or?
Yeah, it is currently free. Mainly, that's really a more a practical and technological issue than I would say, something I want to do. Just login systems are intrinsically rather involved, so I haven't gotten around to setting that up. I would say for the future, I would definitely be interested in either selling subscriptions to the website, just as a matter of blanket access, or maybe doing some kind of consulting. I would say maybe case-by-case consulting on whether a patent portfolio has some kind of defect. I think there's directions worth exploring there.
Interesting. Yeah.
So it's a rather technical question. You planning to do this as like a platform with open access, so that everyone can write an app based on what the information that you extract, or is it like one monolithic software that you just access, like a legal information database?
Oh wait. So you have a question about where the data comes from?
No, if it's
to whom to provide to you the data and how?
Yes. So, well, I basically lucked out here because the patent office is one of the few federal government agencies to make its data available at a very large scale and in XML type formats. And you cannot do this with most other kinds of data. I think even if you want federal court opinions, you can't get it with the level of quality that the patent office provides. So hopefully they continue to do that.
great. All right. So how can people reach you, Yin, if there are some follow-up questions?
Yeah, you know what? I have an email address. It was on the first slide, but I will just type it into the chat box. It's founder@obvious.ai. Everybody has to have an AI domain name now, so.
Of course.
So please
well, thank you.
Yeah, please feel free to reach out.
All right. Well, thank you so much, Yin. Thanks for joining us.
Well, thanks.
And yeah, we'll see you again next week at the same time. Same time, same place. All right. Thank you all.